Good evening to you all. Your Excellency, Chief Justices, Your Honours, distinguished guests from overseas, colleagues and friends, welcome to you all, those of you here in the Banco Court and those of you attending online. I acknowledge the traditional owners of this land, the Gadigal people of the Eora Nation, and pay my respects to their elders past and present. My name's Alan Robertson, President of the Australian Academy of Law, one of the sponsors and organisers of this evening's address and the conference over the next 2 days. The title of the conference is Enduring Courts in Changing Times, to celebrate the bicentenaries of the Supreme Court of Tasmania and the Supreme Court of New South Wales. We have a full and rich program over the next 2 days. You can think of it, if you like, as a prequel to Chief Justice Bell's more formal celebrations in May 2024. I thank Chief Justice Bell for making this court available for the conference. My task, my great pleasure and privilege tonight is to introduce Chief Justice Kiefel, who will address us this evening, her paper being entitled The Creation of the Supreme Courts of New South Wales and Van Diemen's Land. And I understand Her Honour will also attend the history session of the conference tomorrow afternoon to add her lustre to our proceedings. May I, by way of short introduction, read this message from Justice Jenny Blockland of the Supreme Court of the Northern Territory, Her Honour being the President of the Australasian Institute of Judicial Administration. The President of the AIJA sends her apologies for not being able to be here in person. On behalf of the AIJA, she wishes to thank all those involved in organising this conference. It is an honour working with the Australian Academy of Law and the Australian Law Journal, that's the third sponsor, to bring together this group of judges, lawyers and other members of the legal community to mark such a historic occasion. The AIJA takes this opportunity to acknowledge the valuable contribution and dedicated service of Chief Justice Kiefel as she approaches the end of her tenure as Chief Justice of the High Court. We have been especially proud and pleased to have her as patron during her time as Chief Justice. Throughout her career, numerous significant changes to the courts and legal profession have occurred, and many of her personal accomplishments hold their own historic significance, including her appointment as the first female Chief Justice of the High Court of Australia. The AIJA thanks her for her patronage. May I join in those sentiments and add the thanks of the Australian Academy of Law, of which Chief Justice Kiefel is also the patron. The Chief Justice needs no further introduction from me. A fuller biographical note is in the conference program. Her Honour, as you all know, has been a Justice of the High Court since September 2007 and Chief Justice since 2017. We thank her for her commitment and for her fine service as a judge since 1993. Chief Justice Kiefel.
Your Excellency, Chief Justices past and present, judicial colleagues past and present, Mr. President, ladies and gentlemen. My discussion starts at the very beginning of the colony of New South Wales. The earlier period is generally understood as one of convict settlement and authoritarian rule. Courts, albeit of the most basic kind, were established from the outset. It was not too long before pressure grew to replace them with courts more like those in England. These pressures were a response to the many changes occurring within the colony, including to its social groups, commerce and trade, and the effect of the colony's expansion into Van Diemen's Land. The history of the administration of justice in New South Wales and Tasmania may be regarded as falling into three periods. The first being that the first Charter of Justice from 1788 to 1814, the second that of the Second Charter of Justice from 1814 to 1823, and the third from 1823 onwards, when the Supreme Courts of New South Wales and Van Diemen's Land were set up. It is my purpose to focus on what led to the creation of those courts. It is my hope that this will set the scene for the papers and discussions that will follow in this conference, which marks the bicentenary of those courts. Although 26 January 1788 is presently observed as the date of the foundation of the colony of New South Wales, it was on 7th February that there were formal proceedings, which, in the words of the first governor, Arthur Phillip, established a regular form of government on the coast of New South Wales. According to his account, the Royal Commission was read by the Judge Advocate David Collins, appointing Phillip Captain General and Governor-in-Chief of the territory described as New South Wales. The Act of Parliament establishing the Courts of Judicature was next read, and lastly the patents under the Great Seal, empowering persons to convene and hold those courts whenever required, were read. Those patents included what has become known as the First Charter of Justice. Governor Phillip then gave an address. In it, he promised that the rigour of the law would certainly be put in force against offenders, whilst those whose behaviour should in any degree promise reformation might always depend upon encouragement fully proportioned to their deserts. The law to which he referred was English law. He and the documents which were read out that day assumed that the law of England was in force in the settlement. 2 decades before George III, on the advice of the Privy Council, appointed the eastern coast of New South Wales as a place to which felons and other offenders might be transported, Sir William Blackstone had said that English law held that when English subjects inhabit an uninhabited country, English laws are immediately there in force. The basis for this statement, the doctrine of terra nullius, has since been emphatically rejected in Mabo No. 2 in its application to Australia and the Indigenous peoples who inhabited it. But that was how matters stood in 1788. The events of 7th February 1788 were then regarded as laying the foundations of law and order in the new colony. Phillip's reference to a regular form of government having been established may have been something of an overstatement. English law may have applied, but it was a penal colony and a form of military operation. Phillip had 2 commissions, one of which was as a military governor. Nevertheless, the First Charter of Justice established civil courts. The Court of Civil Jurisdiction was to consist of the Judge Advocate for the time being, together with 2 fit and proper persons to be appointed by the Governor. It had power to hear and determine in a summary way all manner of pleas, although an appeal lay to the Governor. A Court of Criminal Jurisdiction was also established to consist of the Judge Advocate together with 6 officers of His Majesty's forces. The first matter heard by the Court of Civil Jurisdiction was brought by 2 convicts, Henry Cable and his wife Susanna. Their story has been recounted a number of times, largely for what it says about the hopes of the new colony. For present purposes, it may be noted that after meeting in Norwich jail, they and their child were transported to the new colony. A public subscription had raised enough money for a parcel of clothes and other necessaries for their new life. The parcel was loaded onto a ship, the Alexander, but only a small part of it arrived. They brought proceedings against the master of the ship, seeking money to the value of the articles in the parcel. The Cables were not married before they arrived in the colony. Theirs was the 3rd marriage solemnised on 10 February 1788, perhaps in response to the admonition by Phillip in his address to the colony that this would be a preferable state of affairs. The first sitting of the Court of Civil Jurisdiction was held urgently because the master of the Alexander was due to depart. The court found in favour of the Cables. The point presently to be made about the proceedings is that the first hearing of a civil action vindicated the property rights of convicts, felons who may have been considered to have been under a disability in bringing a suit. This was not to be the only occasion that convicts used the legal system to assert their rights in the colony. It may be that in a colony principally composed of convicts, many of whom would later be emancipated, any other system would have been unworkable. It may have been confidently predicted that there would not be a great deal for the courts to do in the early days of the colony. Discipline and punishment of convicts was a matter for the governor. The population was small and crimes readily discernible. Surgeon Magistrate William Balmain observed in a letter to Sir Joseph Banks in 1802 that lawsuits had been rare and crimes infrequent. No intricate knowledge of the law was therefore required. But the population had increased over time. Crimes multiplied, property was acquired, and litigation connected to it grew. And rogues regularly devised plans to perplex the courts. Balmain said that seldom a day passed without the commission of a crime or the commencement of a lawsuit which could involve real difficulty. Moreover, there lacked respect for the courts in the colony, partly due to the inexperience of their members. There was a desire for courts more closely approximating those in England. Some change had become necessary. The factors prompting a call for a change to the court system were not limited to those mentioned in the letter. One factor was the power of the governor. There would not be any form of representative government for many years. The first sitting of the Legislative Assembly for each of New South Wales and Tasmania did not take place until 1856. In the early days of the colony, the governor was the principal authority in New South Wales. Whilst the governor was answerable to directions and orders from Britain and could be recalled, the scope of his authority was great. The exercise of the governor's powers took the form of general orders and proclamations, which allowed the governor to pronounce upon a vast range of matters, including coinage and the powers of the justices of peace and probate. The practice caught the attention of Jeremy Bentham, who observed that unlike in Great Britain, where proclamations are mere acts of monition grounded on legislative acts, the general orders and proclamations were more akin to original acts of legislation, and he asked, "This assumption of power, how shall it be accounted for?" The role of the judge advocate also came under scrutiny, as did the lack of qualified lawyers. The role of the judge advocate was unique. Under English law, the office holder was principally concerned with military law and courts martial. But in the colony, the judge advocate had a pivotal role in the civil and criminal courts, as the first charter made clear. The role of the judge advocate in criminal proceedings was most unusual. It has been explained that the judge advocate received complaints, drew up the indictments, and decided if there was sufficient evidence for a criminal prosecution. He then conducted the prosecution whilst presiding over the trial with a panel of military officers, ruled on the evidence, voted on guilt or innocence, and sentenced. These proceedings bore no resemblance to English criminal proceedings, of course. Despite the importance of the role of the first judge advocate, David Collins had no legal qualifications. By 1810, there had only been one qualified lawyer who had served as judge advocate, and he died after only 2 years of service. The civil court's deficiencies became more obvious as trade and commerce grew. In the early years, the tyranny of distance meant that very few ships visited the settlement. But the initiative was taken by some officers, and colonial commerce was founded. Economic ventures in the colony grew with the population. The court may have been suitable for matters involving simple debt or breach of contract, but it was not up to the task of more sophisticated commercial matters, and its summary procedure was ill-suited to them. Another factor prompting change related to the colony's social structure and the status of its inhabitants. In the early years, as was to be expected, there was a sharp divide between those associated with the government of the colony, the exclusives, and those who were unfree. But by 1810, when Governor Macquarie arrived, only about half the population were convicts. There were now those who had become free or emancipated, together with those who came out free but had no official occupation. The free settlers were not always accepted by the exclusives and sometimes joined with the emancipists to seek change. Needless to say, there were at least two distinct groups who had different ideas about status, and in particular, the status and rights of emancipists. A further factor which strained the system of justice established under the First Charter was the expansion of the colony into Van Diemen's Land. It is said that fears of a French expansion into the region led to an expedition in March 1803 for the first British occupation in that land. Another motivation may have been to rid Port Jackson of its most dangerous and riotous convicts. A settlement was established at Risdon Cove on the Derwent River. Its remoteness made it ideal for a penal colony, but it gave rise to other difficulties. At the outset, the settlement on the Derwent River was subject to the jurisdiction of the courts established in the colony of New South Wales by the terms of the First Charter and the New South Wales Courts Act of 1787. In January 1804, letters patent were issued appointing Samuel Bate as Deputy Judge Advocate, but when he arrived at the Derwent River settlement in 1806, he did not have a charter of justice to create civil and criminal courts over which he could preside. This was hardly a satisfactory state of affairs. The time and expense necessary to travel to and from the courts in New South Wales, together with the personal risks associated with travel, proved a practical hurdle. Further difficulties attended the conduct of criminal trials in those courts. The use of mainland courts was therefore largely avoided. The administration of justice in Van Diemen's Land was left principally to justices of the peace, who took an active part in ordinary community affairs. Despite the efforts of the justices of the peace, problems in seeking access to justice were frequently raised in correspondence with England. A catalyst for change was provided by the Rum Rebellion of 1808. It is not necessary to discuss the reason it occurred or to consider its justification. What is presently of importance is that the mutiny precipitated the appointment of a new governor and judge advocate and saw the colony receive renewed attention from Britain. Lachlan Macquarie was dispatched as governor to the colony. Accompanying him was Ellis Bent, a young barrister who was to assume the post of judge advocate. I should add that Ellis Bent is not to be confused with Geoffrey Bent, who was later appointed a judge. As Chief Justice Gleeson observed on the occasion of the 175th anniversary of the Supreme Court of New South Wales, Geoffrey Bent is generally regarded not only as the first judge in New South Wales, but also its worst. In October 1811, Ellis Bent gave an account to the Earl of Liverpool of the state of affairs in the colony which he had encountered on his arrival. He pointed out that the patent establishing the courts of the colony could only have been intended for a very small community where dealings were simple. But, he said, that state of society is now past. The free and respectable population is much more numerous, and the commercial dealings were regularly more complex. He took issue with the role of the judge advocate. He made the obvious point that having been intimately concerned in the preliminary steps of a prosecution, it was hardly possible for the judge advocate to free his mind from some degree of bias against the innocence of the prisoners. The defects of the Court of Civil Jurisdiction were even worse. He raised issues about the composition of the court, the lack of barristers and solicitors, the consequences of litigants appearing in person, and difficulties associated with the absence of rules of practice. Bent offered a solution. He proposed that a Supreme Court of Judicature be established in Sydney for the territory of New South Wales, consisting of one judge, being a barrister of not less than 5 years standing, and 2 persons to be chosen by rotation from magistrates. The court should be vested with full power to exercise all civil, criminal and ecclesiastical jurisdiction, and to make rules of practice and procedure. He pressed for the introduction of jury trials. He also raised questions about the administration of justice in Van Diemen's Land, but conceded that he was not fully acquainted with the situation there. In fact, Governor Macquarie had written to the Earl of Liverpool regarding the problems of the administration of justice in Van Diemen's Land. He reminded the Earl that there was no patent for holding courts there, rendering it necessary for the inhabitants of the settlements of Hobart Town and Port Dalrymple to travel to Sydney. He strongly recommended a separate grant and also suggested that a well-qualified lawyer be sent to fulfil the role of judge advocate. The points raised by Bent attracted the attention of Earl Bathurst, then Secretary for War and the Colonies. He wrote to Governor Macquarie in November 1812, advising that it was intended that there should be established 2 courts in the settlement, one a Supreme Court and the other a Governor's Court. The court to be established in Van Diemen's Land would have a deputy judge advocate regularly attached to it. On 4th February 1814, letters patent were issued. They came to be known as the Second Charter of Justice. The instrument provided for 3 courts: the Governor's Court, the Supreme Court, and the Lieutenant Governor's Court. The Governor's Court was largely a continuation of the old civil court. It could hear all pleas where the sum in dispute was no more than £50, except in cases originating between parties from Van Diemen's Land. These were to be dealt with by the Lieutenant Governor's Court. That court was intended to provide for Van Diemen's Land a system of justice similar to that provided by the Governor's Court for the mainland colony. The main reform was in the provision of the Supreme Court. It was to consist of a judge and 2 magistrates, or any 2 of them, the judge being one. It had jurisdiction to hear and determine all pleas where the amount in dispute exceeded £50, where the matter was worth more than £300, an appeal might be made to the Governor, who would be assisted by the judge advocate. A further appeal might lie to the Crown in Council, where the matter concerned more than £3,000. The court was given power to frame rules of practice. Little appears to have been written about the Second Charter of Justice. Perhaps that was because few regarded it as making significant reforms. Ellis Bent does not seem to have thought so. In October 1814, he wrote again to Earl Bathurst, pressing the suggestions he had earlier made, together with others. In January 1819, Earl Bathurst wrote to Governor Macquarie, advising that a special commissioner had been appointed to make inquiries as to the conditions in the colony. The commissioner was John Thomas Bigg. The commissioner was instructed by Earl Bathurst to first inquire as to the establishment of the courts of justice and whether the later alterations to the court, what has been referred to as the Second Charter, had rendered them adequate. In particular, he was to report on whether the settlement in Van Diemen's Land had advanced so far in population and wealth as to require a separate and distinct judicature. The Commissioner arrived in Sydney in September 1819 and remained in the colony until March 1821. The inquiry resulted in 3 reports, which were published by the House of Commons. The second of them, dated 21st February 1823, was the report of the Commission of Inquiry on the judicial establishments of New South Wales and of Van Diemen's Land. It paved the way for the New South Wales Act of 1823 and the Third Charter of Justice. The historian Dr. Bennett, writing in 1971, observed that few commentaries have been written on the report and that it must be a source of wonder that so critical a document in the development of law and legal institutions in Australia should hitherto have attracted such little notice. This is not to suggest that the big reports or the Commissioner's methods were beyond criticism. Regarding the second report, Dr. Bennett referred to the Commissioner's technique of misrepresentation, distortion and sly innuendo, and that his observations were corrupted by capriciousness, sophistry, and overwhelming prejudice against Macquarie and his supporters, on whom he looked with jaundiced eye. But this does not deny the importance of the report or the impact that the recommendations it contained had on the legal landscape in Australia. The section of the report which dealt with the state of the judicature of New South Wales and Van Diemen's Land raised first the issue of the Lieutenant Governor's Court, which had been established in the latter. The Commissioner observed that trade and commercial dealings in Van Diemen's Land had made very rapid progress, such that the limited jurisdiction of the Civil Court was seriously felt. Merchants and others were placed in an embarrassing position because they had no recourse to a court of wider jurisdiction than that provided by the Second Charter. But it was the want of a separate criminal jurisdiction in Van Diemen's Land that was of even greater concern. He recommended a separation of the criminal jurisdictions of New South Wales and Van Diemen's Land by giving each a distinct and independent jurisdiction. The courts were to be comprised of a judge and a number of officers of the forces. He did not recommend jury trials. Dr. Bennett described the conclusion of the report as a great anticlimax. He said that the ideas had been taken from others and lacked originality. In his view, what the colonists needed was a simple administration of justice with a court freed from military control, the establishment of jury trials, and the assurance of impartial and competent judges. The plea for jury trials can be seen from a petition that had been put before the House of Commons from some free settlers of the colony, which included emancipated convicts. It complained of the composition and procedure of the criminal court, and with the similarity which the court bore to a court-martial. It stated that there were a great number of respectable inhabitants who could serve as members of a jury. It said trial by jury was a great and valued inheritance of our ancestors, which was enjoyed by all the sister colonies in India, Africa, and the West Indies, but was withheld from Englishmen and sons of Englishmen in New South Wales. A similar change should be effected to the civil court, it said. The upshot was that in light of the big reports and the other discussions and petitions of the kind mentioned, the British government passed the New South Wales Act 1823. The 1823 Act provided for the creation, by letters patent, of the Supreme Court of New South Wales and the Supreme Court of Van Diemen's Land. Each court was to be constituted by one judge, the Chief Justice, to be appointed by the Crown. The Crown was given the authority to increase the number of judges for either or both courts to 3. It described the jurisdiction of the courts. It provided that the trial of all crimes, misdemeanours and offences should be prosecuted on information in the name of the Attorney General or another officer appointed for that purpose. All issues of fact were to be tried by the judges and a jury of 7 commissioned officers of the forces who were to take the same oath as jurors in England. Civil actions were to be tried by the Chief Justice and assessors, the latter to be justices of the peace nominated by the Governor. However, where both the plaintiff and the defendant desired having issues of fact tried by a jury of 12 men, a matter could proceed as such under the direction of the judge. It may be observed that although trial by jury had been the subject of much campaigning, the first provisions made for it were rather circumscribed. Thus, the Supreme Courts of New South Wales and of Van Diemen's Land were brought into existence by the Third Charter of Justice, dated 13th October 1823. The swearing in of each Chief Justice was to take place the following year, which, in historical perspective, was when Beethoven premiered his Ninth Symphony. It is to be recalled that at this time, there was still no legislative assembly and there was no proper trial by jury. As the first Chief Justice of New South Wales, Sir Francis Forbes, was to say, without these protections, the people of the colony looked to the Supreme Court as their only protection against absolute power. Such was the importance of its establishment. The Third Charter was intended, as it said, for the better administration of justice in New South Wales and Van Diemen's Land. Despite its shortcomings, it marked the beginning of the establishment of the rule of law and of courts which were to achieve the independence and competence which the inhabitants of the colony had long sought. Thank you.
Thank you, Chief Justice. I'm Francois Kuntz, the editor of the ALJ, and I've been asked to propose the vote of thanks. To do so, just to say thank you, is a very simple task, and we are very grateful, Chief Justice, that you have agreed to open our conference, and by referring to the Beethoven 9, allow me to observe that perhaps you've let off the first of the feu de joie of many fusillades that our impresario, the Chief Justice, has ready to go next year to celebrate the bicentenary of our court. But it's also, I think, incumbent upon me to observe that there is a valedictory tone to this evening, in the sense that this is your final official public speech, as I understand it, in New South Wales. And I would just like to make 3 short observations in that tone about your career. The first is that, as is well known to, I think, everyone in the room, your career has been an extraordinary inspiration to many, in particular, if I may say so, to those who might be anxious about their prospects in the law if their pathway into the law has not been linear or customary, if I can put it that way. The arc of your career has inspired so many. The second, in terms of your judicial service, I think is best summed up as an old debater in the old manner, matter, method approach, in respect of which you would get top marks in all of them. And for that, we are, as judges, incredibly grateful for the example that you have shown. And thirdly, and most importantly, for present purposes, as Chief Justice, you have demonstrated outstanding judicial leadership, characterised by a very public commitment to maintaining and enhancing the institutional integrity of our highest court, both in its output, but also in terms of the working environment of the court, something which I think will stand your memory in great stead in the history of the law in this country. The ALJ, you'll be surprised to learn, will be devoting a few pages to your departure from the court in a forthcoming issue, And one of the nice things about my job is that I get to commission nice things. And so we are in Sydney blessed with Australia's answer to Hogarth or Dormier in the form of Simon Fieldhouse, who I commissioned to prepare a portrait of you that we will publish in the ALJ. And there's no significance to the fact that it's in the doc, but I'd very much like to present you with the original artwork, not only to thank you for your participation this evening, but as a mark of the esteem and gratitude of the entire Sydney profession for everything you've done in your role.
Thank you very much, Justice Kunz. That concludes this evening's session. Those of you who have registered for the conference and are going to attend the conference, I hope to see you bright and early at 9:30 in the morning. That'll be a plenary session, Courts, Legal Systems and the Indigenous People, and Her Honour Justice Julie Ward, President of the New South Wales Court of Appeal, will be chairing that session, and it will include some, we may say, high-powered comparative legal discussion in the form of Professor Val Napoleon, who's the Dean of Law at the University of Victoria in British Columbia, and Justice Joe Williams of the Supreme Court of New Zealand. So I'll see you then. Thank you very much.